Now, the fiduciary duty is a duty which exists solely in common law. We see it arising first in the case of Smith and Fawcett. And Smith and Fawcett is a private company. It has a restriction on the transfer of shares, and the restriction is worded rather strongly. So in Article 10 of the company's Articles of Association, we see that the directors may at any time in their absolute and uncontrolled discretion refuse to register any transfer of shares. Now, Fawcett passes away. He leaves shares to his daughter and his son. They request registration of their shares, so they will then have a holding sufficient to appoint E.A. Fawcett as director. Smith looks at the request for registration of the shares that Alice and Irwin, I believe it is, Irwin Fawcett, own. And Smith looks at the articles, Article 10, and Smith decides, no, I will not authorize this transfer and registration of shares. Instead, he offers to buy shares from the Fawcett children. And then Smith, instead of bringing Fawcett's son into the board, Smith decides to appoint his lawyer to the board. So essentially now Smith and himself, a version of himself or his agent, are running the company. We see Lord Green pop up again. You remember Lord Green from the Greenhall case. And again, Lord Green takes the position that commercial agreements must be respected on their letter and that the court must not play nanny to the parties. And so Lord Green finds that the directors exercise their discretion, good faith, bona fide, in what they consider, not what the court may consider, the interest of the company, and not for any collateral purpose. So if Smith decides that it is in the interest of the company to exclude Fawcett's heirs from influence, and if the articles have given uncontrolled and absolute discretion to the board, then Smith may decide to do this. It is not a breach of the fiduciary duty because, in particular, Smith himself decides what is in the interest of the company, and so by excluding the heirs of his co-founder from the company, he is serving those good interests of the company because he himself has decided what is the interest of the company. You can see once again that Lord Green looks a bit different from what we might decide applying a standard of fairness, or perhaps if you looked at a case decided by Lord Denning, it probably would come out quite different. But the way that he achieves this is by respecting the words of the contract between commercial parties. The Howard Smith case is a Privy Council case, which comes up from Australia. And it is important because we'll see it later. Dicta from this case decided, dicta of this case becomes the ratio decidendi of the leading David Chen case in the fiduciary duty of Hong Kong. So in Howard Smith, what we have is something that occurs a lot in the United States because at this time, under Australian law, the board has the power to issue shares. That is, the members need not vote on an issue of shares. So R.W. Miller Holdings has a shareholder, which is Ampol. Ampol does not get along very well with the current board. but it only has less than 30% of the voting rights, and so therefore cannot remove the board. Ampol forms a partnership with, or a shareholder agreement with a company called Bulk Ships, and raises its voting power now up to 55%. And the board of R.W. Miller is now on notice that Ampol, together with Bulk Ships, may very well vote them out and change the constitution of the board. So what the board does is go to the drawing board and work out a plan. How can they stop nasty Ampol from doing the wrong thing with R.W. Miller? And the wrong thing, naturally, is by removing them as directors, because they are the best directors. They know it for sure themselves. They are the best directors that R.W. Miller could ever have. So what they do is they look for another company, Howard Smith, and Howard Smith will be their white knight. White knight is standard corporate law terminology for a company that comes to the rescue against a black knight, an evil company which wants to damage the board or the company itself. In this case, the board of R.W. Miller see themselves and the board as the same. So then they issue 4.5 million shares to Howard Smith, which then allows Howard Smith to come in and rescue R.W. Miller, because it reduces Ampol and Bulk Ships below 50%, and therefore they are unable to vote the board out. Now, the court looked at this and did not see that there was a conflict of interest. The court decided that the directors of R.W. Miller were acting in good faith without any conflict of interest and did not want to keep their jobs, but sincerely thought that they were helping R.W. Miller. However, still the action of changing the shareholder structure was pretty bad. So they invented a new rule, which is a subcategory of the fiduciary duty that you should add to the board acting bona fide in the best interest of the company as they decide those interests should be defined. And the subcategory is that the board must use its powers for the purpose for which those powers were conveyed, the proper purpose rule. So the Privy Council decides that R.W. Miller did not need funds, and so the allocation of shares was not for the purpose of raising new funds. And so therefore the allocation of shares was used for the purpose of changing the shareholder structure, and therefore the fiduciary duty has been violated, because a new component of the fiduciary duty, as added in Howard Smith, is that all powers given to the board must be used for the purpose for which those powers were conceived, and this is not the purpose, and so therefore the allocation of shares to Howard Smith does not stand. So we go forward then into the future with this. However, we do have Lord Wilberforce's dicta, where he discusses in Howard Smith that if the R.W. Miller board was conflicted, and if they were concerned about keeping their jobs, and that was a conflict of interest, then when they decide what is in the interest of R.W. Miller, that is whether Ampol and Bulk Ships should be able to remove the board, then the court will look objectively to decide what is in the interest of the company. This is very similar to the standard used in U.S. law, where the board is given a lot of free discretion. However, if the board has a conflict of interest, the court applies an objective fairness analysis to what they have done. And so we have that dicta going forward, and we see it then being used in the David Chen decision, the Court of First Instance. So David Chen is an injunctive action. The injunctive actions are together in Part 14 with the derivative action, and they apply the same standard against the director. So in David Chen, you have Tyson Holdings, which has one primary company, which is Tyson Foundation. It creates foundations for companies. It's a very powerful part of their company and generates about 95% of profits. And then they have some other smaller aspects which are relatively insignificant. So Tyson Foundation within the Tyson Holdings company is the key, and it is the workhorse. The members of Tyson Holdings are Francis Chen, David Chen, and Victor Fung. We have some other directors. Now, Francis Chen and Victor Fung got along very well, and they did not get along that well with David Chen. There's a proposal before the board, and there are some irregularities you'll see in the case regarding the board meeting. David Chen claims that the board meeting was improperly called and improperly held. But the court does not go deeply into these questions because they focus on the fiduciary duty argument. So essentially, we have a proposal that Victor, in order to keep him loyal to the company, will be given an option to buy Tyson Foundation at a relative discount. Plus an option to buy more shares if David Chen increases his holding to 30%. The other directors, aside from Chen, Chung, and Fung, did not actively participate in the debate. So David Chen currently has about a 19% holding. He would be the only director to which the option given to Fung would apply. That is, and so we have a sort of a protection which is applied that if Chen were to increase his holdings somehow to 30%, then we would have an automatic right of Fung to increase his holdings. And then Fung receives a discounted purchase of the crown jewel, as it's called. Again, like White Knight, that's another standard term. A company's crown jewel will be the asset that is most valuable to the company. And so Chen complains that this is a breach of fiduciary duties. Now, the response to this from Francis Chen is that under fiduciary duties, the directors decide what is in the interest of the company. And the directors have decided that it is in the interest of the company, given Fung's position in the company, given his importance, and given the fact that we want to keep him loyal. It is in the interest of the company to give this discounted lockup to Fung. And then you'll see that the Court of First Instance draws on the Howard Smith dicta for Lord Wilberforce and brings that into Hong Kong law, creating the rule that if the directors have a conflict of interest, then the court must objectively decide whether what the directors have done is in the interest of the company. And the interest of the company, in this case, is shown not to be served because David Chen produces a Big Four accounting firm evaluation of Tyson Foundation, which shows that the Tyson Foundation company is worth much more than the evaluation produced by Francis Chen's relatively unknown accounting firm. And so this is enough to grant the injunction, and we have this case standing, as the fiduciary duty as applied by the courts in Hong Kong. That when there is a conflict of interest, then the court may objectively determine whether the directors are acting in the interest of the company. And as I said, this is very similar to the majority rule applied in nearly all, at least the U.S. states that I know of. This is the rule that applies. Now we have another aspect of the fiduciary duty, which is when a director decides to compete with the company. So in the Phu Ka Man Jason case, we have basically partners interacting with partnership agreements. That is Jason, his sister Daisy, the provider of the Japanese franchise relationship, Katsuaki, and then Rickey Chen, who is a very well-known chef in Hong Kong. So these partners, first of all, work in ASEAN Ramen. You might have noticed this company throughout Hong Kong. And then they decide to try sushi. So they set up a company called SmartWave, which has as members Jason, Daisy, Katsuaki, Rickey, and then a number of people that Rickey brought in and some other outsiders into SmartWave. And then SmartWave sets up an Itami sushi restaurant. Now, the practice had been for each company set up by the partners to create one restaurant and only one restaurant. So it's questionable whether when Rickey decides to set up more restaurants, whether this is something allowed. And what we have is, first of all, an agreement for the Itami sushi restaurants that's called the Hero Elegant Agreement, which you'll see tidies up the possible allegations of a breach of fiduciary duties against Rickey, and then divides the ownership of the companies and the possibility of opening up more Itami sushi restaurants. However, Rickey is not satisfied. Some people that know his reputation quite well will understand that he is a very ambitious and confident person, and perhaps with more business skill and charisma than his business partners. So he then takes the initiative, and he sets up yet another kind of sushi restaurant, which is the Itacho sushi restaurant. And so then the question is, has Rickey breached his fiduciary duties to the company SmartWave by setting up a company and a restaurant which compete with SmartWave? Should rather he have given that opportunity to create Itacho Sushi to SmartWave rather than taking the benefit for himself? And so you see this is a classic conflict of interest. Rickey is serving himself. He is not serving the interests of SmartWave. And it's a rather long decision, but do focus on the discussion of fiduciary duty. I think you will find it very enlightening. And what we have ultimately is a difficult decision, but what we have ultimately is a finding that there is no evidence that all of the members approved a waiver of the fiduciary duty, allowing Rickey to set up Itacho Sushi, and therefore this becomes a breach of duty. This is a very important case because previous to this, we did not have a modern decision on corporate opportunity in Hong Kong. And so this decision now becomes the leading decision. It was extensively litigated. We have a number of lower court decisions because it's very complex. And then we have the Court of Final Appeals decision that I've asked you to read. Now, as I said, this is a very long decision, so please do focus on the facts and the discussion of fiduciary duty.